This is Andrew Bosin. I'm a software attorney. I am located in New Jersey, right outside New York City. I represent software, mobile apps, SaaS, startups, vendors, companies, and developers in drafting, reviewing, and negotiating software app development agreements related to the development of a mobile app, a software app, or a SaaS app. I also will review the statement of work, which accompanies the MSA agreement and deals with the actual project that's being built or deliverables that are being delivered. This video is for informational purposes only. It's not legal advice. I want to go over some of the issues that I believe are very important in a software development agreement, whether it relates to a mobile app or let's say a SaaS app. One of the most important clauses that should be in this agreement deals with intellectual property. Who owns the deliverable that's being created? Who owns all the underlying intellectual property that goes into the software that's being built for you? There's a term that's called work made for hire. And what it generally means is that even though you're, let's say, paying a developer to develop an app for you, that without language in the agreement that says work made for hire, that app being created by the developer could be claimed as ownership by the developer because it could be subject to copyright laws. So it's really important that if you are having an app developed, that the development agreement states that it's a work made for hire and all the intellectual property, the deliverables, and the software related to the app belong to you, the client or the company having the app developed. The only time you really wouldn't have to do this agreement is if an employee of yours develops an app because it belongs to the company. Let's keep talking about intellectual property and what that means. I see a lot of software development agreements out there. I've seen a lot have been drafted, and what I try to do is I see a lot of different terms that relate to intellectual property, different paragraphs that relate. What I try to do is create very well-defined terms for deliverables, software, the services that are being performed. And I try to put them all under the umbrella of quote unquote intellectual property. So even though there might be separate definitions, in the definition of intellectual property, I will state that these are all considered intellectual property. And why is that important? Because if you're having an app developed, you want your agreement with the developer to state that you own all of the intellectual property, the software that is being developed for you, and that the developer is giving you all of the intellectual property rights for that software that's being developed. And it's very important if they have outside contractors helping the developer, they need to sign agreements stating that the software is work made for hire and that they're also transferring all of their intellectual property rights in the intellectual property software or deliverable to you. What is also important is that sometimes developers will use open source software or other pieces of software in developing your intellectual property. You want to make sure in your developer agreement that it says that either the developer owns all the software they're using, or they have a license to use the software, and they're in turn giving you a license to use the software that makes up your deliverable in perpetuity, basically, which is for life, to use the software. And why that's important is you don't want to have a situation where your app, let's say, is in the App Store and some third party comes along and says, hey, there's no way you could have created that app without my software, and then you call the developer and he's like, yeah, I'm using third party software. I don't really have a license for it. And then you wind up getting sued. That leads me to my next category, which is indemnification. Indemnification basically is, let's say the client are using your app and you get sued by a third party that claims that part of your app software is made from that third party software and your developer didn't have a license or the right to use that third party software in creating your app. So the term indemnification comes along where in your agreement you want the developer to indemnify and hold you harmless and pay all of your damages, claims, legal fees in defending the claims against the third party. Typically, the developer will come in and assume the defense of those claims and pay whatever damages, verdicts, legal fees that come down the road. Costs and fees. Never, never, never give the developer all their money up front. If it's $25,000 for the total project, put a little bit down, and then you want to do milestones. Milestones are nothing more than just markers along the way in the project. Building front end, great. When all the bugs and defects have been tested, I'll pay the next amount. The next one, doing the back end, when all the bugs, defects are fixed by the developer, I'll pay the last amount. I wouldn't give the developer final payment until until your app has been approved by the app stores. And I also would try to get some sort of warranty that for the first year of the app's existence that the developer will fix all bugs and defects with the app. It's also not a bad idea to get a maintenance contract with the developer so that they can fix the software when iOS and Android does a push. No matter where you're located, if you need help with a software app development agreement, please call me, Andrew Bosin, at 201-446-9643.